everyone who is an employee will have an employment contract, whether that be implied or whether that be written. If it's an implied contract, then you as the employer are probably not in a particularly great position at all in terms of protecting your business. Having a written contract in place, well, by way of example, if someone comes to me saying, actually, I've got an issue with my employee, it's X, Y, Z, first response, 99 times out of 100, will be, what does the employment contract say about that? If someone says, oh, there isn't an employment contract, I think me or any other lawyer that you come to start rubbing their hands together and saying, oh, fantastic, there's a bit of money to be made here. The reason why? Because there's complete uncertainty about the legal position. The more certainty there is in the contract, the less scope there is for horrible lawyers like us to argue with other horrible lawyers about what's actually meant and intended. A lot of small businesses in particular will not have employment contracts in place, we tend to see. And actually, sometimes those are the ones that need most protection from some of these things, like restrictive covenants, like protection of their intellectual property, having good notice provision in there, having good probationary periods, giving some proper thought to benefits and bonuses and such like, having clear provision in relation to holidays, sickness absence. Importantly nowadays also having an anti-corruption bribery type policy in there to avoid exposing the business significantly. Also, particularly sadly in the current economic climate, thinking about whether it would be sensible at the outset to have some kind of temporary layoff or short-term working type provision in the contracts. Looking first then at restrictive covenants, I think restrictive covenants are an interesting one. We see a big range of restrictive covenants in contracts, from contracts that have no protection whatsoever when there really should be, to people who will try and stick restrictive covenants into every single contract for every single employee when they're totally inappropriate. The key thing with the restrictive covenants is that they have to be really tailored and fit for purpose. What they do is effectively they can prevent people from basically setting up in competition with you, from poaching your staff, from soliciting customers, and from actually having left you from even dealing with people who they dealt with when they were with you. There is, though, in the background a big public policy issue there, in the fact that public policy says you don't want to have trade restrained too much. So everything is set against that. So the basic premise is that you can protect a legitimate business interest using these kind of clauses, but they can't go any further than is absolutely necessary. That's one of the biggest problems we see a lot of. I think we occasionally see, particularly if someone's not given any real thought to it, so you'll have a kind of telephonist and you will sometimes see a contract that says you can't work in the retail sector anywhere in the world for the next 6 years. Is that reasonable? No, of course it's not. If you do have one where, for example, you have your head of sales, you operate just in the local Plymouth Devon market, in a very niche, let's say, medical sector, would it be reasonable then to have something in there saying you cannot work within the Plymouth area for a period of 3 months in a competing business in the medical science sector? Yeah, probably would be. And actually, if it is reasonable, if it is enforceable, then the courts are going to enforce it for you. So it can be very important to protect the business. It's judged at the time the contract's made. So actually, if someone then gets promoted up and up and up, you should really be thinking about updating those restrictive covenants as well. Must be clear and certain, so any big vague terms in there are going to be interpreted against you. Things that are affecting reasonableness, so duration, how long is it going to be? Kind of 3 months, 6 months, probably reasonable. 12 months, 2 years, 3 years, probably not. Scope, as I was saying, in terms of geography, where are you wanting to prohibit them from acting? And in terms of the activity, as I was saying there, so if it's a particular sector that you wouldn't want them to compete in, you have to be quite clear. The employee's business and the employee's role and position in the business. Obviously, if someone is very, very senior within the business, then a longer, wider restriction is probably going to be a bit more appropriate than if someone's very, very junior. Whether the covenant is usual in the employer's industry is an interesting one. So do speak to people in your own industry, see what the norm is. The other terms and conditions of the employee's contract, that I'll link back to in a minute, but that's things such as what kind of protection have you got in terms of the notice provisions in the contract. As I say there, the court doesn't have the power to completely rewrite a covenant. So actually, if you've stuck one in there that's very broad, very wide, very long, that person's going to go to a lawyer, and the lawyer will say it's completely unenforceable, just ignore it. Whereas actually, if it's very tailored, very specific to an individual, then it's going to be pretty powerful. Protection of confidential information and intellectual property. Now, we had a bit of a chat around that in the commercial contracts section. You'd be amazed, really, how limited the protection is on the whole in terms of the basic protection if you've got nothing in the contract to deal with it. Confidential information, there's several types. So broadly, trade secrets, mere confidential information, or employees' skill and knowledge. Now, broad brush, the default position, if there's nothing in the contract, all that's going to be protected realistically are your trade secrets. So it is the Coke recipe, just in case any of you are wondering what the picture related to. That would be protected, but very little else would be. So trade connections, knowledge about your business plans, etc., broadly aren't going to fall under that trade secret category. So actually your protection is very limited unless you have some clear-cut protection built into the contract, or actually as a separate confidentiality agreement that we do see quite a lot of, that you get people to sign. If you do have a clause in there that's actually well drafted and sensible, it's going to be much, much easier to enforce and use that to bash someone over the head with later on. It does make sense, though, to very much tailor that to your business. Work created in the course of normal and or specifically assigned duties, again, you can cover that in a suitable intellectual property clause. The classic one that we always see is the, oh no, I did that in my own time at home, it was nothing to do with work. Well, actually, if you'd covered that off in the contract, you would have been well protected. Include obligations to disclose IP created, assign all rights and do all things necessary to assign rights. That's a classic one that a lot of people don't cover. If you've got a clause in there, you can actually say in the clause in the contract, you know, when you leave, by the way, you have to assign any intellectual property for anything that is effectively belonging to us, and actually we can force you to do that and require you to actually sign it over at the time when you have to comply. Probationary periods, notice entitlements and garden leave. Pretty critical. Probationary periods are an interesting one, perhaps an underutilised resource in a lot of ways. I think all of you probably know now that this unfair dismissal claim limit's now been kind of increased to 2 years service before you do that. But don't underestimate probationary periods. They can be quite a useful tool to exit someone fairly safely if it's just not a good fit at the initial outset of the relationship. If you are going to use one, make sure you use it properly. So actually, if you incorporate in within that, you know, set periods for discussions and reviews, have goals, monitoring, etc. Garden leave, a massively underutilised resource, actually. We're talking about restrictive covenants, notoriously difficult and quite complicated in terms of enforcement. But what are you trying to achieve from the restrictive covenant? Normally, quite often the case, it's keeping them out of that business arena for a set period of time. If someone's got a 6-month notice provision in their contract, you can keep them out of the business community for 6 months very easily using a garden leave clause and simply saying to them, by the way, no, you are still employed, but you can't speak to any of our customers. You just have to sit at home watching Jeremy Kyle, pretending you enjoy it, and actually do nothing. In some sectors, that can be amazingly powerful, particularly if it's a very fast-moving sector where knowledge is growing and changing all the time. Having 3-6 months out of the completely out of it can be quite damaging to someone, but it can be very useful for you as the employer. It also gives you that period of time to then secure those relationships with customers, bring in someone else, and basically protect your business a lot better. In terms of a suitable garden leave clause, you want to build in there things like that they have to return their BlackBerry, their laptop, everything else. If they've got a company car, you might want to say, well, actually, no entitlement to a company car during your garden leave, thank you very much. Interestingly, you could also say in there that the employee has to remain in contact during the garden leave period, that they can't go out of the country or anything else without your say-so. And you can also require that they take any unused holiday entitlement during that garden leave period. So actually you're not then having to pay this annoying lump sum of holiday when they do actually go.